Well, thank you everybody again for joining us, and thank you, Dennis, for being here. So Ryan's going to kick us off.
Great. Thanks, John. So I think when we think about, a lot of us, at least when we think about this SF City Attorney's Office, we think about the affirmative litigation program that Luis, John, and Dennis Aftergut, our speaker today, had worked so hard and had such a big hand in developing and expanding. But I think what often gets overlooked is the office's role in the development of what I'll call, at least, affirmative legislation. And that is policies adopted by the San Francisco Board of Supervisors to not only improve the lives of San Franciscans, but hopefully serve as a template for progressive change that can be implemented by other cities and counties across the country, and even in some cases, the federal government. Policies that, when adopted more broadly, can help, to sort of allude to the topic of today's talk, bend the curve towards justice. I think some notable examples in San Francisco are, the Healthy San Francisco Universal Healthcare Law, which was the first time a local government attempted to provide health insurance for all of its constituents. And of course, the Equal Benefits Ordinance, which requires firms to provide goods or services to the city to administer benefits equally to employees with domestic partners and employees with spouses, and that being the first in the United States, and really a path-breaking law because at least 19 other jurisdictions have subsequently adopted similar ordinances. And we're incredibly lucky today to have, one of the chief architects of that law and defender of that law, Dennis Aftergut, who, I think as you look at the readings, they provide a great window in sort of some of the obstacles, the ways in which the city attorney's office is critical to the development of these types of sort of affirmative legislation, sort of are twofold. One is, working with the board to craft the legislation in the first place from both a policy and a legal standpoint, with possible legal challenges such as preemption in mind. And two, what you got a flavor of in the opinions you read for today, actually defending the legislation in court if and when it's challenged, and trying to uphold as much of it as you possibly can. As I said before, Dennis, our guest today, has extensive experience in this field. I'm going to leave it to John, who's had the privilege of working with Dennis much longer than I have, to give a more extensive personal introduction. But before I hand over the mic to John, I do want to briefly touch on some of the work Dennis is doing right now, some of which I've had the privilege of helping out with a little bit. He currently works with the Coalition to Preserve, Protect, and Defend, CPPD, which is an organization dedicated to upholding the rule of law. The organization was formed to participate in litigation supporting governmental accountability, just laws, open government, and to protect the public's right to an independent and impartial judiciary. Some of the examples of CPPD's recent work include, and by no means is this an exhaustive list, filing an amicus brief in the Ninth Circuit, arguing that Sheriff Joe Arpaio's criminal contempt conviction should not be vacated despite the president's pardon, which I believe resulted in an opinion from the Ninth Circuit, maybe not adopting every aspect of the amicus brief, but siding with CPPD's position. And then the work that I actually was able to work with Dennis on, successfully lobbying the New York legislature to close a loophole in the state's double jeopardy law that could have allowed any president to abuse the presidential pardon power by unfairly granting a pardon to a family member or close associate, and possibly allow that individual to evade justice altogether. So those are some of the things that Dennis has been focusing on now. He's certainly going to get into some of the stuff I alluded to before, but I'm going to kick it over to John to finish the introduction of Dennis.
Yeah, so I'm going to go quickly because I don't want to cut into Dennis's time, and I can already see him going, you're cutting into my time. I know, that's how well I know Dennis. Dennis was chief assistant in the city attorney's office when I was, eventually chief deputy. He was number two, I was number three. Dennis
2.1.
2.1, right. And he also is the guy who recruited me to the city attorney's office. I don't know if I would have gone. I was at Morrison and Forster, and I was convinced, well, I should say, everybody had convinced me that going to the city attorney's office, and this was a time when the city attorney's office was not viewed as you guys all look at it probably as a pretty good office, maybe even a very good office. It was not viewed that way. It was viewed as a very dreary, bureaucratic law office. And Louise had gone out. She only recently become city attorney and hired Dennis and a couple of other people who were real stars. And so had it not been for Dennis's hiring and Dennis recruiting me, I'm confident that I wouldn't have gone to the city attorney's office. Dennis served in the office, I don't remember the exact number of years, but 10 plus years. And I worked with him very, very closely during that time. He is one of the most thoughtful lawyers who I've ever worked with, and we've worked together also to some extent on the CPPD stuff, the Coalition to Preserve, Protect, and Defend. So I will say that the equal benefits case was sort of, I think in Dennis's mind at least, the pinnacle of what he did in the city attorney's office. And our running joke was that once he got a taste of this sort of affirmative legislation and being a leader in an area that made it, really made this kind of difference, that it was the beginning of the end. Because at that point, Dennis no longer wanted to work on like the other stuff we were working on. So at some level, I kind of lost Dennis to this case, and after that, soon after that, after the case, he left the office. So it has a little bit of an unfortunate side, but obviously the upside was a great result. So anyway, Dennis, you're on.
Am I coming through? Okay.
Yeah, good.
Okay, so it's a real honor to be here. You guys are beyond impressive group. Let me just say before I get into it that John always underplays his role, or maybe this was Ryan underplaying John's role, but CPPD, which has been my mission over the last 3 years since November 7th, 2016, was John's idea. And like most of the things that I do, I'm a very good executor of John's ideas. And John, as you know, is just rich in creative ideas, including your fellowship. I also want to say about the Joe Arpaio case, which was the first case that we did in CPPD. We actually argued that the pardon was unconstitutional. That we were an amicus and that didn't get any place, but it was righteous with a lot of great other amicus organizations. If you guys don't mind, if you're willing, because this is Zoom and it's important to me to know a little bit about you, a little bit beyond the, your CVs, which I read and, as I say, blow me away. But if you'll indulge me, I'd like to ask you to go around the horn here and, in a minute, tell us two things. The first thing is, and I'm going to do this first, so you're going to have time to think about it. Maybe I'll ask John to do it, and maybe I'll ask Ryan to do it. But John, we all have to be brief. John spends a lot of time roaming around. He's got a very, very large mind palace, and there's a lot of space to roam around in.
And get lost and confused.
Yeah. And we'll get lost with you. Anyway, here are the two things. First, I'd like to ask you, what's one of your top 3 values? And I know from John that every one of you is uber concerned right now about what's happening in the country, and I nothing but admire that. But I'm asking you to go like sort of a step of abstraction beyond that. What drives that, or anything else you want to say? And I will tell you that my top 3 values are social justice, personal integrity, and intimacy and human connection. And this, now I'm acting on my third value. I want to feel a little bit of connection to who you guys really are. I want to know a little bit about who you are. And the second thing I want to ask you, only if you're willing, is something a little bit more personally revelatory, if you're willing. It could be a personal concern you're having about yourself right now. It could be something else. But I'm going to tell you, you know, if you've read my CV and you listen to them, you think, oh, this guy is really impressive. You know, he's argued in courts low and high and won awards and things. I'm nervous right now. I'm telling you, I can't go into a court and I can't present on Zoom and I can't present in front of any small group without getting nervous. And that's my reveal about myself. John, you want to go? Give them a little time to think?
Sure. So I would say that my strongest values are, I don't know if this is exactly a value, but you know, is creative and aggressive problem solving. I don't know if that's a value. And communication. I'm in the business of, do a lot of labor negotiation, although that's by no means all I do, but so it's a big part of what I do. I would say that the thing that is on my mind right now is I am what I guess you would describe as a pragmatic policy guy, right? And I am wondering whether my pragmatism is making me blind to the emotion behind the moments we're witnessing in the country.
Great concern. That's a great concern. Thanks. Ryan, you want to go? You don't have to.
Oh, sure. Although integrity, you know, I feel like I'm an also ran with that, but that would be one of them. But I think helping others is even more important to me.
Right.
And in terms of something that's on my mind, I think, you know, thinking a lot about excessive force right now. And I don't know that I'm thinking about it pragmatically, but yeah, that's something that's.
Is there something that you're concerned about yourself personally?
I think I, like you, have always have anxiety when I walk into a room and have to talk in front of a bunch of people. I moved around a lot growing up, so I got good at doing it, but it doesn't change the anxiety of having to perform and get up there.
Yeah, let me see how impressive you were. Okay, anybody want to, John, I don't know how you facilitate this.
I'm going to do it in order just for ease of not having everybody go, wait, so that's going to put Michael first.
Right. Well, beyond what's already been said, I care a lot about fairness and equality and democratic inclusivity and elevating depressed voices in our society. I'm sort of recently been concerned about my work habits because I don't have a lot of my normal outlets. And I find myself just constantly working, just sort of phasing in and out of working at different levels. And I can find that sort of, at one point I'll burn out, not yet, but I feel like maybe it's coming. And as a side note, by the way, Dennis, I realized that I'm recognizing you from the Laurel email thread.
Yeah, I know your grandfather is the leader of that group.
All right, Jake.
Yeah, I think probably my top value would be sort of, I guess, open-mindedness or empathy. I think being able to come at a problem or someone's emotions or someone's position and really come outside of your own perspective. I think if more people could honestly do that and like commit to doing that, it would be, you know, things would be a lot better. And then something personal that I'm concerned with right now. I think for me personally, it's a lot of times it's about time for me. I came to law school a little bit later. I'm usually around a bunch of amazing people who are more than a few years younger than myself, and just feeling like I have to catch up is something that I deal with personally.
Interesting. Okay, Kelly.
I feel really strongly about giving back, and especially to my community. I'm in such a privileged position to be in law school and to have a master's degree and to have all this access to education that I really feel like it's my part to do something good with that, to help not only my local community, but hopefully, you know, the state or on a broader level, and to use that for good. Something that I've been struggling with, especially recently, is to sort of not lose faith in humanity. There's so much ugliness out there that really gets focused on, and especially when you're on social media. You know, I have to hold on and surround myself by the good people and remind myself that, you know, we're out there fighting the good fight, and, you know, we can overcome these challenges.
Iba?
For me, I think similarly to Jake, my strongest value is empathy. I'm really focusing on that, and just making sure that people realize that we all walk different paths, but if you can put yourself in other person's shoes, that's so valuable. My biggest concern right now would probably be my mental health. I think it's hard for me right now to put my phone down because I'm constantly reading the news and checking out social media. And sometimes I just feel the pressures of the world that it's our responsibility to make it better for the future. And it feels really like almost there's never any good news. And so being able to kind of tell myself that it's okay to put my phone down, it's okay to kind of take a walk and clear your head. It hasn't been easy, but I'm trying to be better at it.
Garvey?
Yeah, so I would say my values are probably courage, individuality, and selflessness. Courage and the fact that I feel like, you know, despite the fear, like you guys said, whether or not you're nervous or not, always having the courage to always, you know, go out and do what it is you want to do. And the individuality aspect of it is being true to yourself. And then the unselfishness, the selflessness aspect is like what some people mentioned before, giving back and sort of bringing others, lifting others up with you. And I would say one thing that that's on my mind right now is really sort of figuring out my role to play. I know the battles that I want to fight and sort of the good that I want to do with my career, my law degree, but sort of figuring out exactly how I can best utilize my skill sets and my passions to really have the biggest and strongest and most lasting impact on my community and the greater society as a whole. It's kind of what I'm trying to figure out right now.
Allison?
Yeah, I think two values that have guided me that I think about a lot are compassion and responsibility. I think compassion is similar to what Jake and Hiba discussed about empathy. It's kind of thinking about where people are coming from, kind of trying to put yourself in others' shoes and figure out how you can be more empathetic. So in a way, it's similar to what's already been discussed. And then responsibility is kind of taking that information and taking what I've learned in that process and trying to contribute, kind of having a responsibility to kind of use that information in a way to make the world more inclusive or to make the world better, kind of how do I contribute based on that information? I think those are the two values that I think about a lot. Something that's been on my mind lately, I think, has probably been on everybody's mind, just kind of what is the future of the world post-coronavirus? Is there a post-coronavirus world? Just the uncertainty is something that I've been thinking about a lot. You know, I'm starting at a new school in the fall on the MBA side, and certainly have been involved in a lot of discussions about what that will look like. And, you know, more broadly than that, that's just kind of the more immediate impact, but just more broadly than that, kind of what is a world with coronavirus in it now, for good, it seems like, going to look like. So I'm sure that's to some extent on everybody's minds, but that's something, that uncertainty is something I've been thinking about a lot.
Susanna?
Okay, the most important value to me is commitment to social justice. I feel that's like part of my trajectory always, and something that I'm trying to stay committed to and not be jaded or move away from that, really, especially in law school, where it's very easy to feel depleted and feel like nothing can change. Personal concern, sort of similar to Jake. I'm a little bit older to feel a little bit behind, but and then also because of coronavirus, I have to completely readjust my next academic year so I can find internships or a part-time job to, fill in the gaps in my resume. Yeah, so trying to figure all that out while dealing with coronavirus and all the issues happening with Black Lives Matter and hoping something comes of it, and also climate change and not forgetting that that's also a huge issue. Yeah, so it's just a lot of issues, but I'm hopeful.
As I said, you're a very impressive group. Thank you for that. I feel like I know you, at least some small things about you, so much better, and it makes it easier to connect. Two quick things before I start. Number one, this started with Kelly, but I heard this with others. Look up Mike, is it Michael? No, it's not Michael Collins. Jim Collins, Stockdale Paradox. In a nutshell, the Stockdale Paradox is face the brutal facts, keep the faith. You'll read about how he came. Stockdale was a prisoner of war with McCain in the Hanoi Hilton, up to his neck in water. It's real. Face the brutal facts, keep the faith. And the second thing I've already forgotten. Okay, so I will launch. And what I'm going to do just structurally here is I'm going to give you some background to the litigation, how it started. I'm going to go through these 7 lessons, squeeze in quickly another lesson or two if I have time. But I'm not just going to present here. I want to go through maybe 2 lessons at a time and then stop and get your questions rather than put them all at the end, just to make sure that you're at least somewhat engaged. This is basically, I hope this is entertaining. It's war stories. There's just a lot of great war stories out of this case. I know what the second thing was. I came back to it. So let me interrupt myself. The reason I ask about top values, and I don't have any doubt that you guys are going to do this, but the more time in life we spend in our values, and we spend a lot of time at work, and the law, if we get in the wrong place, can distract us from our values. And there's a lot of pressure on you guys to pay student debt and other things like that. And law school channels us into directions that aren't necessarily consistent. John, how long did you spend at Morrison?
4 years.
Yeah. And you learn a lot in those places. I spent some time in private law firms, not much, but you learn a lot. But I learned quickly that it's too hard. Practicing law is too hard to do it on things that don't speak to who you are. So that's kind of the takeaway I hope you get a piece of. All right, so I'm going to start a little bit of the background. All you guys are really interested in what happened to George Floyd, and the just immovable racism in this country. And this is a story about a different kind of invidious discrimination. Less people probably getting killed in the modern period, certainly now. There's a lot of hate crimes still against gays and lesbians, but still invidious in lots of ways. And you have to put yourself to hear the story in a different mindset from today's mindset, because this happened 20 to 24 years ago. Some of you might not have even been born. Some of you might have been newborn. Some of you when this started in your infancy. And it happened 18 years before, I think the case is Obergefell, which in 2014, in which the Supreme Court said, blessed gay marriage. In 1996, when this started, John, how far back, how far would you have estimated in 1996? How long would it take for gay marriage to be a reality in the United States of America? What would your guess have been?
My guess would have been, 50 to 100 years.
Spot on. Mine too. That's what everybody thought. So the fact that it happened in 2014 is a shock, but the idea that I want you to have in your head is the way you've, lived in your adulthood is a long way from where it was there, which is a tribute to the power of the movement of gays and lesbian and transgender people to move public opinion in this country, that moved the Supreme Court. It really is about activism. But we didn't imagine it. So back in 1996, what I was defending was viewed as the wackiest idea on the face of the earth. Now, that wasn't new to San Francisco because, as John's probably told you, San Francisco is always pushing the envelope. In fact, it's not just the envelope. San Francisco pushes the whole Costco supply of envelopes, the whole post office. And this was an idea that was greeted with, oh boy, there they go again. That's the mindset you need to be in. And that was kind of my mindset too, when I first got into it. Here's the background. In 1996, here's something you probably aren't aware of. William Jefferson Clinton, President of the United States of America, signed the Defense of Marriage Act. The Defense of Marriage Act said, in the event that some state should adopt same-sex marriage, the federal government does not recognize it. There will be no benefits. You can't file your tax returns jointly. And, that was a terrible piece of legislation that President Clinton signed. Well, 3 activists in San Francisco, now welcome. I thought somebody new joined. It's Art Hartinger, but somebody using hearts. Anyway, 3 activists in San Francisco, Jeff Sheehy, Jeff Kors, and Carol Stewart, they were pissed. And one morning in February 1996, they sat on a rooftop in the Castro district, the gay district in San Francisco, and on the theory, think globally, act locally. Gays were probably the most important constituency, political constituency in San Francisco at the time. Would you say so, John?
Yeah, absolutely. Yeah, they were. Yeah, I mean, San Francisco was thought of at this point as really being the gay capital of the world.
So these 3 activists knew that through the community, through the activism, that they're activists themselves, they had power. They could do things with the Board of Supervisors. And on the theory, think globally, act locally. And on the theory, don't get mad, get equal. They came up with this wacky idea. And the idea, as Ryan told you, was we'll have the board adopt legislation that they could do because of their powerful constituency and their organization. A piece of legislation that said San Francisco contractors will provide benefits to people with domestic partners. I always said, in San Francisco, there was domestic partnership, but there were no benefits to speak of associated with it. And you didn't have to be, gay to be in a domestic partnership. You had to register and say you're living together with someone. Because I used to say that in San Francisco, we don't discriminate against people just because they're straight. That's a joke. It was an attempt at a joke. But that idea evolved from we'll have, we'll mandate domestic partner benefits for employees of companies that work for San Francisco, to we won't mandate benefits. This made the case easier to defend. We won't mandate benefits. We'll mandate equality. Company X, United Airlines in this case, you don't have to provide your employees with domestic partners any benefits at all. But if you provide benefits to your employees with spouses, you need to do the same. So it became part of San Francisco's non-discrimination provision. And that non-discrimination chapter of the municipal code has a long and righteous history, starting with discrimination. Companies who are our contractors cannot discriminate on the basis of race, moving to gender, moving to sexual orientation, and this became part of non-discrimination against, non-discrimination based on sexual orientation. You know, a form of equal compensation, because, John, what percentage of compensation is in benefits?
These days, depending on whether you're talking about safety employees or non-safety, somewhere between 50 and almost 100%.
Whoa.
But that's
I was going to say 25 or 30.
No, that used to be, but pensions have swallowed that. So
It can't be 100% because people get salaries. But the point is,
let me do the math for just 1 sec. I mean, so the issue is health benefits for a family is $24,000 a year. So if you think about a lower level employee, a miscellaneous employee or whatever who makes under $100,000,
right.
You see how you get to my number pretty quick.
Right. So the $24,000 in health benefits, of course, covers the employee. But if the employee has a spouse, you know, it might be $10,000 of compensation because, or it might be 12, I don't know. But the point is, you are a gay man or a lesbian woman, you can't get that. You're not getting equal pay for equal work. And that's why this is was invidious discrimination. And so, you know, the board adopts, but who thought that we would ever be able to mandate health benefits? And the answer is no legal expert, and they were all quoted in the newspapers. This idea is DOA, when somebody sues, dead on arrival, when somebody sues San Francisco, because the federal health benefit legislation, ERISA, Employee Retirement and Individual Security Act, has a powerful preemption clause. Who knows what people know about preemption? Somebody tell me, raise your hand and tell me about preemption. What's preemption?
You can just unmute yourself and go for it, or not.
I'll do it if you don't know. But so I'm glad I asked if people, or maybe you're shy, maybe you don't know. But preemption means that the feds have said either expressly or they've in fact occupied the field of health benefits. But they've said expressly in ERISA, no state or locality shall regulate health benefits. We're in charge in the federal government. So here we are saying companies have to give health benefits. Dead on arrival. And then the second thing about the legislation is background. So the second thing is it was extraterritorial. It said, if you're a San Francisco contractor, you got to provide those benefits, those equal benefits to your employees everywhere in the country. Well, there's something called the Commerce Clause and the Due Process Clause. And it says, gee, San Francisco doesn't really govern New York City. You can't tell companies or people what they can do outside of San Francisco. And that's what this legislation said. So keep in mind, there are two primary claims: preemption and extraterritoriality. Under preemption, if you read the case or even if you didn't, it wasn't just ERISA preemption. They had labor law preemption, and they had a specialized law in the airline industry, because this who sued us, called the Airline Deregulation Act, and there was a preemption clause in that too. So there were three claims related to preemption. There were two claims or three related to extraterritoriality. That's to keep in mind as I get to talk about the legislation. So I am sitting in May, the law is adopted in November, and I'm going to end soon and stop for questions because I'm talking too much. The law is adopted in November of 1996. Raise your hand if you were alive. Garvey was not alive. Okay, good. You get my point. But if you were alive, you were, not cognizant of discrimination against gays and lesbians, to say the least. So, I got lots of projects in the city attorney's office, and I'm sitting at my desk one day, and in walks Louise Remy. You've met Louise, right?
I think they're actually, she's been on the phone a couple of times. She's actually, they have a session with her this afternoon on affirmative.
Great. Good. Well, you'll see. Louise is the nicest, sweetest person in the world.
Except when she isn't.
Except behind closed doors if she's pissed. Don't go there. You won't see any of that. But yeah. She's the nicest person. She comes in and she says, would you look at this case? In May, 5 months after the law is adopted, because it had a sunrise provisions. We're not going into effect for 6 months, so people can adjust to this and get used to it, and we can get our regulations in place and so on. So in May, shortly before June 1st, when the law is going to go in effect, United Airlines, they're the main mover, hiding behind, they're not named as a party. It's the Air Transport Association, their trade association. They recruited all the other airlines to join in because guess what? They don't want to be the target, the consumer target of active gay and lesbian people in San Francisco. Oh, we're all acting on this together. And we're airlines. You can't tell a national carrier what to do. Oh, and United Airlines, why were they involved? Because they had contracts with the city, property contracts at the airport for gates. Those are all by contract. And for facilities, all by contract on San Francisco's property. So they're subject to the Equal Benefits Ordinance. They got a pretty good common sense claim. You can't tell us what to do in New York and everywhere else they fly. So in walks Louise. Would you take a look at this case? Louise is such a sweet person. She doesn't say, would you handle this case? No. Would you take a look at this case? I knew what that meant. Despite my social anxiety in front of people, I harbored my own political ambitions. Louise wasn't going to be the city attorney forever. I was the number 2. So do I want to be associated with a barking dog like this case? With the most important political constituency? Do I want to lose this case? I'm identified as the loser? Louise, I will be happy to take a look at it. I'm not sure I have time to handle it. Boundary, shut up a boundary. Okay. And that ties into one of the lessons, keep the expectations down. I ask 6 lawyers in the office to take each cause of action, research it, put together a binder of cases, and we'll have a meeting in 2 days and give me your evaluation. We go around the table in Louise's office. 1, 2, 3, 4, 5, 6. Oh boy. All right, I'm still going to do my own. Due diligence. And this is lesson P.0. Allison, you're going into business, and in product development, P0 is sort of the first stage, even before it's an alpha site. P0. This is, there's no shortcut for doing the work here. You just have to go read the cases in litigation. And I'm sure every other way. And it's, now I've got 3 huge binders of cases, and I go home and I read the cases. I'm going to stop and ask for questions.
Questions, guys?
Yeah, don't feel obligated. I can talk way past the.
You're pretty entertaining, so.
I'm fading?
I said you're very entertaining, so everybody's enjoying listening to you. I know.
Might have a question.
Okay, good.
Dennis, were you afraid that if you lost, I mean, beyond your political ambitions, that it would jeopardize anti-discrimination ordinances across the country?
Oh boy, what a great question. I didn't plant that question, everybody, but you've anticipated lesson number 2, which is about keeping expectations low. I, being appropriately humble about my knowledge about everything, I called a guy named Matt Coles. Now we got Susanna is at Hastings and Garvey is at Hastings and Jake's at Hastings, right?
Right, that's right.
Right. So Matt Coles taught at Hastings. I don't think he teaches there anymore, but was he there when, you're a rising 3L, was he there when you were there, Garvey?
Still there.
Still there.
Yeah, Professor Coles.
All right. So what does Matt Coles teach?
Constitutional law.
Sorry?
Con law.
And I'll bet he teaches a case about gay and lesbian law. No?
That I don't know. I just know for a fact he teaches con law.
Okay. So Matt Coles, you should meet Matt Coles, and if you haven't taken his course. Matt Coles was responsible for the first domestic partner ordinance back in 1980, where it just created this category. It didn't even mean anything but that was the stepping stone. Dianne Feinstein vetoed it. That's how homophobic the culture was in 1980, and it got overturned through an initiative measure. So it became the law through a public vote. Dianne Feinstein, she would never do anything like that now, but that's the way it was. And Matt Coles became the ACLU's head of gay and lesbian law. And the ACLU, some of you have probably had some personal affiliation. I mean, they have the best lawyers. And he was based in San Francisco, New York. I called up Matt and I said, Matt, I'm looking at this case, and this goes back to you, Michael. How could you let the Board of Supervisors set back the movement that way? So here's the guy. He's the chief advocate for gay and lesbian rights. And he says, you motherfuckers, how could you do this to us? Wasn't me, Matt, wasn't me. I just got the case. So, but that's going to become useful as part of the story. Anybody got a question, or shall I go on? Okay. So I take home my books and I study for 3 days. And after studying for 3 days, a light bulb goes off. It's so obvious when the light bulb goes off, but nobody was talking about this. Everybody was talking about what benefit? Garvey, aren't you the one that is into health and wellness?
Yes.
Yeah, so what was everybody talking about when they think about benefits?
Sorry, I don't understand the question.
What were they talking about? They were talking about health benefits. That's all anybody could think about. Okay? And health benefits, that's, probably the most important benefit generally.
Right.
But it's the one that we were crushed on. And I did find one case called Alameda Newspapers that created an exception where a municipality was just acting as an ordinary consumer doing business, not a regulator. If you're regulating, you're preempted. You can't regulate in this area. But if you're just a company like, you're just Bank of America or Wells Fargo or some company that's insisting on some policy and you can't regulate, just have ordinary power, yeah, maybe there's an exception. Okay, but mainly you're crushed by ERISA. But the light bulb was, hey, health benefits aren't the only benefit here. There's lots of other benefits. We called them non-ERISA benefits. And there's little ones, relatively little, like non-paid family leave. I say little because it didn't cost the company anything except for the absence of the employee, that if your spouse is sick, you can take off and take care of your spouse without using your vacation time. Or bereavement leave. Your spouse dies. You can take some days off to grieve without using your vacation time. And then in the airline industry, lo and behold, there's a huge non-ERISA benefit. Back in the day, I don't know what it's like today. Back in the day when flights weren't full, I know they're not full today, but they were before Corona always. If there's a seat on the flight, your spouse can fly free wherever you want on that airline, standby. So you stand by, you get on the airplane, costs you nothing. Oh my God, that's why a lot of people become flight attendants, because they can, travel on vacation free. And there's, they also had an emergency flight benefit. So I got a family member across the country who is suffering from coronavirus, and I just need to be closer, not that close, but closer. You don't have to stand by. And if it's a spouse, you don't have to stand by. You can go and your spouse gets on too, free. It's your parent, you fly across the country, there's an empty seat at the time you call, you're on the plane, no standby. The company gives up its opportunity to make money, and they give you that seat to take care of their employee. But if you're a gay or lesbian employee, or you're straight and you have a domestic partner, that doesn't apply to your domestic partner. But the main thing is equal pay for equal work. Sorry, just turn that off. Oh my God, there is some things we can win if we can get past Airline Deregulation Act preemption and labor law preemption. And those are not nearly as strong as ERISA preemption. Just take my word for it. I got this other problem about extraterritoriality trying to regulate in New York. And I realized, well, okay, but we can do this in San Francisco. We can do this probably on property that we own outside the boundary of San Francisco. Hey, San Francisco Airport is outside the boundary of San Francisco. Right, John, isn't it? Yeah.
Yeah, it's in San Mateo County.
Yeah, and San Francisco owns the Hetch Hetchy Reservoir by Yosemite, supplies San Francisco with all the water that it has. We got a lot of contracts related there. Can we apply this law on that property that's outside our boundary? Chances are really good. And then there's a category number 3. There's some cases that suggest that if work is being done in Nevada or New York that relates to our contract, we can apply our conditions on that work. So, slam dunk, San Francisco, likely win property outside of San Francisco, and maybe win related contract. And then the 4th category is everywhere else in the United States. I'm going to come back to that. But I'm saying, oh my goodness, we can win. If we win unpaid family leave for gays and lesbians, that's a victory. And, how progressive are most judges? How quickly do they want to move to revolutionary change? No, the law is a conservative instrument, just one little step at a time. Well, Brown versus the Board of Education didn't spring full-bodied out of the head of Zeus or Thurgood Marshall. Thurgood Marshall, there were at least 10 cases he had before Brown versus the Board, building up to it, creating precedent, each one expanding equality before he attacked separate but equal. One step at a time. hey, we can be, I don't want to be presumptuous, but maybe little Thurgood Marshalls for gay and lesbian rights. Just, this is a starting step on the road to equality. And I said to the lawyers who joined on our team, this is why you go to law school. And you guys will all have cases, I hope. May you be so lucky as I was, that, that really live out why you went to law school. This was it. This case had everything. Social justice, my value. Intellectual issues, I like those. Community connection to these activists. This case had everything. So I have this light bulb and off we go. Let me stop for any questions that you might have. Raise your hand, otherwise I'll keep going.
Mads?
And nobody's raised their hand.
Okay, all right. So that either means that they're shy or they're asleep or, whatever. Anyway, I was that was John. Thank you. That's what I was fishing for.
Right.
And that brings me back to Matt Cole's, Michael, and it brings me back to the next lesson, which is the first lesson. P0 was got to do the work. P1, the first lesson was one step at a time. P2, this product number 2, the second lesson is the value of low expectations. You can't lose a case that everybody thinks is a loser. And this lesson about low expectations, boy, take that seriously as a lawyer advising your client. It's really fun to go in and say, we're going to win this case. Be careful. There's a lot of traps for the unwary in law, and your client's not going to like it if he thinks you're going to win and you don't win. But if you lose, and he expects you to lose, well, you did good. It was a good try. So everybody thought this case is a loser, dead on arrival. So shh about one step at a time and what we can do. And I got Matt Coles on my side. So we go to the board of supervisors, lead to 3 gay supervisors, and we kind of brief them on what we're thinking about the case. I got Matt Coles on the telephone. Matt reads them the Riot Act. This is good, John, right? Yeah. So, by the way, this is one of the side lessons. This is an important, just tactical lesson. John, you've used this. I got Matt Coles, very respected, third-party consultant. Consultants are really useful to deliver bad messages to your client. You don't want to deliver a bad message to your client. The city attorney also, there's a history of the city attorney saying no to everything. So we're starting swimming upstream because they trust us, but they trust Matt Coles. And those supervisors, and I'm able to say, well, Matt, there may be a few little things we can win. Okay, thank you, Matt. I'm looking good with my client. But they get the message. You know what they say? This law is not going into effect for another 2 weeks. All I want you to do, just keep it alive for one day. We just want it to go into effect. That'll be a victory. Get it, John? Okay. I got a floor that I can stand on. I can do a lot better than that, I think. But that's my floor. And instead of having some ceiling that I'm going to bang my head on. So I take that floor and I use it moving into the next lesson. And the next lesson is sometimes the best defense is not a good offense. Sometimes it's rope-a-dope. Raise your hand so I can see if anybody knows where rope-a-dope comes from. Okay, Jake, go ahead.
Yeah, rope-a-dope comes from Muhammad Ali, I believe. He was it George Foreman? I'm pretty sure.
Muhammad Ali.
Well, no, but
Muhammad,
who he was fighting? I think it was during
Frazier. I think
Frazier.
it was. Yeah.
Yeah, but he let him. He just hang back on the rope and played defense until he punched himself out. He was too tired to. And
his opponent got tired.
Yeah, and then he won then he beat him up.
Yeah, he sits against the ropes. You guys aren't boxers, some of you, I'm sure. I'm not. But he sits against the ropes in a clinch. Joe Frazier, he slugs away at Muhammad Ali's arms, never hits his body, never hits his head. Those are the vulnerable places for a boxer. And then in round 10 or 11 or something, Ali sees an opening. Boom! Down goes Joe Frazier. I'm the greatest. I'm still the greatest. And the thing was that, why did he use that? He used that, you guys will like this. Do you understand that Muhammad Ali is one of the greatest living, he's not living anymore, but he was one of the greatest figures of the second half of the 20th century, bar none. Muhammad Ali was of age and at his absolute prime as a champion when he said, "No Viet Cong never done nothing to me. I ain't going to that war." He got drafted and he went to jail. That's somebody who's living by his values, but he wasn't in his prime when he came out, and he was out of shape, so he had to do rope-a-dope. And on January 1st, when our law was going to go into effect, and when these guys had scheduled a preliminary, the airlines, a preliminary injunction hearing, we were not in shape. We were not by any means ready, but my instruction was keep it alive. So I called up Brendan Dolan, the hotshot lawyer from the other side. And I go into rope-a-dope. Brendan, I don't know why you filed 6 causes of action. All you needed was ERISA and the Commerce Clause. Oh my God. And Brendan laughs smugly. And of course, Brendan is from the fancy downtown law firm. And he doesn't think that there are good lawyers like you who are willing to give up big money to work for the city of San Francisco, which doesn't really have the totally greatest. Maybe by that time we were doing better, but I guarantee you, he thought any lawyer at that firm was better than any lawyer in ours. So, rope-a-dope. And then I say to Brendan, this airline, whatever it was, whose contract is coming up, making application ripe of the equal benefit, they got a new contract. The equal benefits ordinance only applied prospectively when you sign a contract. Didn't apply to old contracts. Now he's got a client that has to sign a new contract. His contract's expired. I say, Brendan, I think that here's why the equal benefits ordinance doesn't actually apply to that situation. And Brendan, we're going to work out every time we can to see whether or not this, there's some way, some workaround. It doesn't apply. And, if we have to, maybe we're going to create a little, say, okay, well, we'll give them a pass. So what does that do? Preliminary injunction's not ripe. So they don't have a contract coming up and they can't go to court, and we have the law alive for more than one day, but we certainly have it alive for one day. And what happens is that as it goes into effect, the City and County of San Francisco's Human Rights Commission administering this ordinance gathers compliance. Companies start complying. And companies start realizing, hey, there's a competitive advantage to giving equal benefits. We're going to attract and retain employees, gay and lesbian employees who are talented, because other people in the industry, other companies don't give equal benefits. We're paying them more. And by the way, that's how this very, very positive virus spreads. One company puts it in effect, and then the competition forces them, like dominoes, to do it all over, throughout the whole industry. It had gone through the tech industry, and now it's gone through a bunch of other industry because this law is in effect. And while that's happening, we're gathering evidence that this doesn't cost that much, and what it costs is worth it to these companies. And we're gathering evidence that there's a competitive advantage. It's good for the company. Because on June 1st, we didn't have any evidence to go into court and do a preliminary injunction. You need to, have colorable facts to help you with your legal arguments. Rope-a-dope. Sometimes the best defense is a good defense. And just, wait, let things happen, and when there's an opening, then you strike. Okay. What's the next lesson? Use your competitive advantages. Okay, good. So the other way of saying that, this is John's favorite lesson. The house holds the cards. It's hard to beat the house. Can't fight City Hall? Well, this is our legislation. And so we go to I've told you about preemption and that, we can get equal benefits, but we got to deal with, the law says this applies everywhere in the United States. So we go to the Board of Supervisors and we say, hey guys, how about to improve your chances of keeping this alive another day, you amend the legislation. You amend the geographic provisions of the legislation. And what you're going to do is you're going to break it down into 4 parts. And you're going to say, this law shall apply in the city and county of San Francisco, A. B, on property that San Francisco owns outside its own boundaries. C, anywhere in the United States where the work is being done that relates to the contract. D, everywhere else in the United States. John, tell them why we added everywhere else in the United States. We knew that was a loser. That can't win. Why do we do that?
Well, you had to give the court something to knock off to make it a compromise decision.
Well, that's good. That's good. Anybody else have? I think that's right, but it wasn't the primary thing, not the initial thing. Anybody?
I mean, the main thing you were doing was severability, obviously.
Yeah, well, I'm going to get to that, but well, good. Why don't you talk about severability, John? Just go ahead.
Well, so, basically, if you got it as one sentence, right, if the whole coverage is one sentence, the court won't sever it because it's not clean. In simplistic terms, the severability doctrine basically says, if it's something you can strike out while the rest of the law still sort of makes sense, then it can be struck. But if you've woven it into the fabric, you can't do it. So this allowed them to go straight down a list and go, okay, yes, this one's okay, this one's okay, this one's okay, this one's not okay. So
the severability clause says, the court shall strike if there's a provision that's unlawful, and the court can sever it and separate it and keep the rest of the law alive. That's what the court should do. And we had, I don't remember if it had a severability clause or we added it, but that's what we were doing. But the reason for, there were 3 I thought, even number 3 I thought I had a shot at, but I knew I didn't have a shot at number 4. So right. The reason to add that, besides what John said, is what do politicians like? What don't they like? They don't like looking bad. They like to save face.
I'll say that,
so the law continued to apply across the United States on its face, even though we knew that D was going to get severed.
You didn't have to waste all your energy trying to convince the Board of Supervisors to retrench. We could let the court do the work on that issue because we knew we were going to lose it, but you didn't have to.
How much do your clients like retrenching, John?
Especially in a highly politicized issue.
Right, with a lot of attention. So we help them save face. but because the House held the cards, oh, there's a problem, we just go fix the problem in the legislation. And so I get to throw somebody else under the bus. I won't name anybody, but I wasn't involved until, 5 months after it was adopted and Louise walked into my office. I didn't, even though Ryan tried to give me credit, I didn't have anything to do with the drafting. I had to do with fixing it so it would survive, because I don't like losing. Use your competitive advantages. Now we've got a defensible ordinance we can win some pieces of, and we're gathering evidence that we can use in the preliminary injunction. It comes to, maybe January or February of, January, I think it was, of 1998, 6 months after the law goes into effect. And we're ready to find our opening and punch. So we refuse, when FedEx has a contract coming up, to find any exception or not to apply the law. FedEx is located in Memphis, Tennessee, and its president at the time, Fred Smith, I don't know if he's still the CEO or the founder, very homophobic guy. So they weren't going to bend, and we were at issue. I was in touch with, I mentioned to you, one of the strengths of this case was community connection. And I know there's a bunch of you, Heba, maybe Garvey, maybe Susanna, with La Raza. And I'm sure there are others, sorry for missing you, but community, working with the community is really, really important. So I called up the head of the gay and lesbian chapter of the mechanics union at United Airlines. And, we had a good conversation, and he's saying, if there's any way we can help, let me know. Well, one of United's claims was, in the preliminary injunction, Judge, we're going to suffer irreparable harm. That's one of the standards. Because if you force us in the middle of this litigation, before you decide on the merits, to grant equal benefits, and we win the way we're going to win, says Brendan Dolan, we're going to suffer irreparable harm, because our gay and lesbian employees are going to be happy, and then we're going to take those benefits right away, and their morale is going to be damaged. That's going to do us irreparable harm. So it occurs to me, we could have those employees come in and testify, no, it won't cause us harm. We'll be so happy to have it for a day or a week or a few months. We're okay with that. If it has to get taken away because you say so, we're good. Our morale is not harmed. So I go to John before I invite the mayor and say, John, what do you think about having these guys come in? And I say, John, their employer's not going to like it, but the law protects you, your free speech and your right to participate in litigation, even against your employer. John, how does that go over?
I'm trying to think back, but I'm sure I said they're going to get fired and bad things are going to happen to them.
Yeah, and they're going to get retaliated. You can't retaliate against them legally.
Yeah, but that's like saying, yeah, right. I mean,
go ahead.
Well, it's just, retaliation is very insidious. I mean, so, good luck when they apply for the next promotion. And good luck proving it's because they testified.
Exactly.
I don't remember what I said, but I think that's what I would say if you ask me now.
That's what you said, John. And I said, oh, shit. Okay. And I called them up. And the lesson here is, and Garvey, you talked about this as a value of yours. And you know what? I can feel chills as I just think about starting to talk about this segment. In fact, I can feel tears in my eye. I call them up and I say, we would love to have your testimony on this, but you can't do it and we can't let you because, and then I quote John Holtzman, you're protected legally and the house holds the cards. There's always a way they can get you. You can't come in. And you know what they said? We're not going to the back of the bus. And we're not going to the back of the plane in this case. And in they came, about 15 of them. And I said to the other guys on the team, and I just want to say something about the team. This case had so much going for it. I got to pick cream of the crop. There was a lot of cream, and I didn't pick all the cream, but I got a lot of really good lawyers who wanted to be part of social justice. And these are really good lawyers, and they come from law schools as good as yours. And I told them, I need a 2-paragraph declaration. My name is X, I work at United Airlines, my morale will not be hurt. I'm sitting there writing up the legal argument, and the lawyers come back with 5-page declarations. And I say, no. 2 paragraphs. And they say, and I'm going to choke up again. I really am. No, you got to read this. You know, I'm a flight attendant at United Airlines. My domestic partner of 17 years is a pilot, was a pilot. He got AIDS and died. I asked for bereavement leave, and they said, sorry, you need to use your vacation time. That might not sound like harm, but if you think about it for a second, you're in grief. Your domestic partner, the person you love of 17 years, has died. And what is your employer telling you? You're a second-class citizen. At the moment of grief, okay, declaration number 2. I get a call at 2 o'clock in the morning. My parents in Orlando, Florida, across the country, have been in a car accident. My father's dead. My mother's in intensive care. United Airlines, I pick up the phone, I call United, and they say, emergency flight benefit, you are on the next flight out. I say, this is what the declaration says. How about my domestic partner of 20 years? Oh, sorry. If your domestic partner wants to go, you have to fly on your domestic partner's standby status. Your father's dead. Your mother's in intensive care. Your employer says to you, you're a second-class citizen. And the lawyers on our team looked at each other and said, I just got an email, Michael, from someone named Joe Groden. The lawyer said, we better fucking win this case. Courage is contagious. And we didn't win that preliminary injunction. I won't bore you with why, but that was a watershed moment in this case. How am I doing on time?
You've got 25 minutes.
Okay. Okay, I can do it if there's not going to be a lot of time for questions at the end. I'll do my best. I'll try to.
I can't read everybody's faces, but I have a hunch they'd rather hear you than hear themselves.
All right. So lesson number 6: sometimes your enemy is your friend. Don't settle. So don't settle. That's, there are times when settlement in lawsuits are good. In our lives, let me just say, as someone 3 times older than you, almost, don't settle. Whether that's in your job choices, or your choices of partners, don't settle. So we got an order from the judge in the case requiring them to go to mediation. You know what? I'm happy with one step at a time. Maybe I'm going to get bereavement leave. Maybe I'm going to get unpaid, family leave. Maybe I'll get flight benefits. Who knows? We go into mediation with an experienced, great federal judge. Well, you can't order people to settle. And this United Airlines, at the time anyway, the executives were former pilots, very conservative culture from suburban Chicago. They're not giving this up. This is threatening to them. They don't care that much about gay and lesbian rights, and there's a principle here. We can't let cities tell us what to do across the country. So, failure. Sometimes your enemy is your friend. Don't settle, because the bottom line is we won all the ERISA at the end. In the summary judgment motion, we won all the ERISA benefits. And I'm sorry, non-ERISA benefits. And the judge said about ERISA, I kind of like that Alameda County newspaper case, with the exception that when a municipality is just acting as an ordinary consumer, then ERISA doesn't apply. You're just doing business like everybody else. You're not a regulator. But in this case, you're trying to apply it at the airport. How many choices do airlines have about where they go? Oh, they can fly to Oakland, they can fly to San Jose. You have too much market power. You're kind of a monopoly. In effect, you're regulating. You're not an ordinary consumer. You lose. Can't require health benefits. Okay, but she liked our exception when we're acting as an ordinary consumer. This law wasn't put in place to regulate airlines. This law was put in place nobody's even thinking about airlines. Everybody else. Oh, we can require everybody else to give health benefits. To this day, San Francisco, for people who don't want to get married and just want domestic partners, still gives health benefits just to domestic partners of employees of city contractors. Still requires the company to give those health benefits. And before Obergefell and gay marriage, believe me, across the country, hundreds of thousands of people got health benefits because we won that little dictum. And we just kept going. And I'll just tell you as a coda, when we won, when the case became a final judgment and they filed a motion in the Ninth Circuit to get an injunction while they were going to win everything in the Ninth Circuit, they lost that, and United Airlines turns around and guess what they say? We're going to be the first company. We don't have to do this. Under the judge's summary judgment, we don't have to do this. We're going to be the first airline to give health benefits to our employees voluntarily. Those snakes, we're going to be the first. They enlist all their other airlines into this coalition to fight this. And then they turn on them and say, we're the first airline. We got all the good publicity. I mean, we're happy, but, what a good partner to the other airlines they were. Anyway, we won health benefits. As a practical matter, we won everything. Okay, but there's a step in between. But the lesson is, don't settle in your life. There are times to settle, right, John? You got to settle sometimes.
Yeah. Definitely.
But my judgment about when to settle in that case was wrong. I was hedging. I was, going for a win, not risking a loss, but I was wrong. Don't settle. Okay, last lesson. This is my favorite one. It involves, talk about revelatory admissions. It involves a humiliation, personally, and it involves one of the things I'm most proud of in my life. So the background is this. We only got sued by 2 parties. I think most people didn't want to be on the other side of this issue with, you know, the gay and lesbian population, most companies. Oh, by the way, I meant to ask, are there questions about what I've said so far? Anybody got a question? Okay. So there was a second case, and the second case was called SD Myers. Maybe you read the opinion. And SD Myers was a company that provided generators to us at Hetch Hetchy. And SD Myers, and by the way, I forgot to say about our win. The judge gave us 1 A, B, and C. We won in San Francisco on extraterritorial. We won in San Francisco. We won on property outside of San Francisco. And we won in Chicago, where United Airlines administers our contract. So, wow, good. Well, we didn't win everything because we didn't live in the United States. It wasn't expanded to the whole country, but you know, that wasn't going to happen. Okay. And we had kept the board's expectations low by telling them, we feel pretty good about A and B, we're not sure about C, and we know we're going to lose on D. Keep the expectations low, your client. Okay. So SD Myers provides generators at Hetch Hetchy outside our property. And SD Myers' president is a fundamentalist. I ain't doing nothing for no gays. And SD Myers represented by Pat Robertson's Legal Defense Fund. You know who Pat Robertson was? Anybody? Go ahead, tell us. Kelly.
Yeah, he like has his own Christian network and his own university, and it's pretty conservative in his beliefs, social beliefs, and very Christian.
Right, right. Gay and lesbian people are cursed. They have God's curse. So that was this guy, and that was their lawyer. And I've had other cases with those kinds of foundations. So I don't remember whether Jay Sekulow was the head of that one or the other one that I had a case with. You know who Jay Sekulow is? Trump's personal lawyer. Wow. Very accomplished, very smart guy. Quite an asshole. So anyway, Pat Robertson's representing him, and it's a fundamentalist. They're not going to bend. And I'm thinking, you know, there's something that bothers me about we've won summary judgment. This case was behind the other one. It was filed afterwards and resolved afterwards. We've won summary judgment. The judge has given us non-ERISA benefits, and I'm saying to myself, something bothers me about this. Oh, one more thing. This is now the dangerous case. It's not an airline. We're an ordinary consumer. The issue is joined as to whether ERISA is going to preempt us. We can lose health benefits in this case. And by the way, New York City had a copycat law, like Ryan said, and they lost on this issue. I think it was maybe a little later, but they lost on the issue. So, you know, this is dangerous. Something bothers me. Here's why it bothered me, and here's the personal revelation. It sounds good to start with, so bear with me. If you're lucky enough to work for the government as a lawyer, and you're lucky enough to have a boss who, for whatever reason, likes you, you get a chance to argue in the Supreme Court of the United States. I had my 15 seconds of Supreme Court argument. And for any of you that want to be litigators, oh my God. I won't bore you with what the case was about. It was an uphill struggle. We're arguing against the First Amendment. But I developed an argument that my moot courters, former clerks of the Supreme Court, said, we hate your argument. You're against the First Amendment, but you could win. Okay. So I go in full of confidence on my argument on the merits, and I win the case. I win the case on a technicality. I win it on standing. My consolation is, okay, maybe I made it hard enough that they punted and found some other way. That's my self-consolation. But as I told John, I tell people, I am such a good lawyer. I win cases on grounds I don't even argue. I didn't argue standing. Everybody in the world, except for John and now you, thought I was a winner in this case. I won the case, bottom line. Personally, what a humiliation. You argue in the Supreme Court. I had no business being there. You argue in the Supreme Court of the United States and you win on the ground you didn't even argue. Oh my God. I said to myself, and what their opinion, they were down in the weeds on these different elements of standing. Redressability is one of them. That the relief that the plaintiff is asking for won't really help them. It won't redress their grievance. But I say to myself, I will never, ever make that mistake again. I will never, ever handle a federal case as a defendant and not consider every damn last corner of justiciability, of standing. So here I am, fast forward 7 years. Something's bothering me about this case. Boom. Oh, this is a fundamentalist represented by fundamentalists. We've won non-ERISA benefits. In order to get a contract from the city, you've got to say that you will comply with the ordinance to whatever extent it's valid. We already know non-ERISA benefits are valid. We send a request for admissions to SD Myers. If you were to get this contract, would you grant non-ERISA benefits to domestic partners of gay and lesbians? No way, folks. Against our principles. Boom. They can't get a contract. Boom. Their ERISA claim is non-redressable. In other words, Judge, you can say whatever you want about how legal or illegal our requiring health benefits is. It doesn't make any difference. These guys can't get the contract. Whatever you say, you'd be issuing an advisory opinion. I tried this out on Matt Coles by telephone. I say, blah, blah, blah. He says, what? I say, blah, blah, blah. He said, oh, that's interesting. That's interesting. We won. The judge never got to the merits. She dismissed their complaint, and nobody ever challenged it again. To this day, we are giving health benefits to employees of domestic partners. And I'd say at least 100,000 people have benefited from that, because this is the part I'm proud of. Learn from your mistakes. I got humiliated. There's always a learning opportunity in a humiliation. And I learned, and what I learned had far more effect than my humiliation. That had no effect. What I learned got health benefits for many, many people. And that is one of the ways that if you learn from your mistakes and you're working in an area that you value, whether that's voting rights or Michael, or whether that's, equal access to education, or whether that's environmental law. Kelly and Susanna, I think, are interested in environmental law. And Jake, whether it's, crimes and punishment, or being a public lawyer. You got to work in the city attorney's office. I saw that nice picture in City Hall. But whatever it is, whatever your values are, spend your time there. Because if you are fighting for your values, you'll have an incentive to get smarter than you would have been, to learn from your mistakes. And what I take real pride in is that if I didn't have that mistake, that wouldn't have happened. And I don't know how many other lawyers that would have happened for who didn't have that mistake. There are some, sure, smarter than me. but I wasn't smart enough if I didn't have that mistake. So spend your time, spend your profession in your values, and you will be a better lawyer than you could ever be if you were spending them outside your values. And not only that, you'll be happy. Questions? That's it.
Now is the time for questions.
Michael, go for it.
Yeah, I just wanted to rewind to the moment when the supervisors told you to keep the ordinance alive for just one day.
Yeah.
Was that employee retention effect sort of a planned strategy, or was it more just that they wanted the, I don't know, the sort of public rallying around the ordinance? What was the thought behind the strategy there?
John, were you paying attention, John? I know you're on. You got messages.
Yeah.
The question is, why did the Board of Supervisors say just have it in effect for one day? Was that for employee retention, or was there some other reason? Why would the Board of Supervisors, why would Tom Amiano want the law in effect for one day?
Yeah, because they want to be the authors of the first law in the country that did this thing.
They want to save face. They want to be able to say something they did. This wacky law that everybody thought was a failure. Okay, they're okay. Everybody knows it's a failure, but get it in place for one day. We have something to say to our constituents. We're politicians. We got to run. We don't want to run on, it was a wacky idea that never went anywhere. At least it was in effect for one day.
Yeah, I mean, you have to put yourself back, Michael, a little bit in the era. I mean, we're just in such a different era now on gay issues, gay, transgender, et cetera, issues than we were then. I don't think we knew, in fact, I know we didn't know, that there was this massive group of gay people who worked for companies and other places, and for that matter, for the city, who, we didn't understand that these were matters of dignity in the way that we understand them now. We didn't understand how powerful they were as consumers, how powerful, they were going to be, and how, in some ways, organized, although not organized in in sort of the traditional sense of that term, but that they were going to really move the needle in a way. I don't think we really had thought through that part of it at all.
Of course not. Just two quick points, because I want to make sure everybody has a chance to ask questions who wants to. Number one, about the part of this case that was so great about working with the activists. Oh boy, they ran a soft boycott of United Airlines, the activists, and they made it politically incorrect to fly United, unless you had to, because United's a hub in San Francisco. You didn't have all that many choices a lot of times, so it's okay. But believe me, when a politician got caught on a United Airline flight, public hell to pay. So, and that was a powerful, I'm sure that was powerful, and probably more powerful in the litigation, in United Airlines turning around and saying, we're going to be the first in the country. They wanted to stop that boycott. So, we're working with activists, and what makes social change, law is an important tool, but it takes organization. Ask Barack Obama. It takes, it takes constituents, and it takes leaders of the constituents, like Jeff Sheehy, who didn't give a flying about what people thought. He dressed up in Teletubby costumes. He got TV attention outside of United's headquarters. These people, let it all out. If you are working with those people as partners in litigation, social change is on its way. Bread baking in the oven. The second thing, John said something really interesting. Us straight guys, we didn't know about, there's this important constituency and consumer group. Well, guess where else besides City Hall and these companies? At Brendan Dolan's law firm. We learned, which lesson did Brendan Dolan not know? We learned, how did we learn this? Brendan Dolan told his client, This case is a slam dunk. That firm doesn't exist anymore. It's not because of this, but I'm sure Brendan Dolan is still practicing law. But anyway, you know, he probably suffered for that. Okay, questions?
I think you got Jake.
Yeah.
Hi. So my question, this case, you kind of described it as like a case that why you go to law school, and it had a good outcome. I was just wondering if you had a case that you felt like was one of those cases that you really were passionate about and felt like this is a case why you go to law school, but that didn't have a positive outcome, and how you sort of dealt with that, or how that affected you.
I don't think I had a this is why you go to law school case like that. You know, the few high visibility social justice cases that I had, I think I did pretty well on the outcome. But you raise a really, really good point. And I've learned this lesson the hard way through the blows that, you know, life has struck me and my family life. And that is, and you know, this is the opposite of what you get taught as a lawyer and the ways you operate. And John might not even like it that I say this, but one way that being a lawyer is in tension with your own, shall I say, serenity, as in, God, grant me the serenity to accept the things I cannot change, the courage to change the things I can, and the wisdom to know the difference. Outcomes are not in our control for the most part. We can lawyer as well as we can and end up with a bad panel. And, you know, that's the end of that. So that's why it's important to live in your values and focus on, this is what I can do, and I'm taking satisfaction and getting serenity out of fighting for this. And I gotta let go of the outcome. Oh boy, is it fun when you win. Oh boy. But John?
Yeah.
We don't always win, do we?
Although one thing you failed to mention in the House Holds the Cards is you have to remember one of the great things about being in government on the legislative side of things, when you talk about trying to bend the curve legislatively, is you always get a second chance. If you don't get it right in that first piece of legislation, and we've sometimes had pieces of legislation, because for one thing, we don't necessarily control it. I mean, we may try to make the legislation as good as we can make it if the sponsor will let us. You know, we don't always have complete control over those kinds of issues. But what is very cool, and it's something that Dennis did, which you sort of heard about, but you only heard about it sort of sidewise, I think, a little bit, is you can go back in the middle of litigation or even after litigation and enact a different ordinance or change the ordinance or flex. And it's one of the great joys of local government, because, you know, you got your majority, whatever majority you had. All you've got to do is think of a better idea, and you can be back out there fighting it again. And, you know, some of these things kind of are that way. I mean, you know, some of these ideas, you know, you come up with ideas whose time has come, which was the case of, you know, Dennis's case. We didn't know that going in, but you also come up with ideas whose time either hasn't yet come or may never come. You know, I mean, I'll give you just a sort of a humorous example of that. One of the opinions I had to write, wasn't litigated, was on essentially cultural sensitivity in the area of public health. The public health department wanted an opinion that said that every public health clinic, because in San Francisco, they specialize in different communities, had to be staffed by people who were from those communities. And you go, Well, I get why that's great from a cultural sensitivity perspective, but you do realize there's this long history of customer preference cases that basically say, you know, I mean, that's a twin-edged sword. Seriously, are we going to say only white people can work in white clinics? You know, very problematic issue. So my point being, not all ideas that come out are good ideas.
John, I think that's a really, really good point about local government. And my only very modest qualification is that still the decision makers are not you. So if for whatever reason, it didn't happen in this case, of course, but you know, you can have, you know, a majority of legislators who don't share your interests. They're going to decide you could try to do something, and they say, sorry, we're not going to do it. And guess what? Because they're politicians and because they're human beings, sometimes they make those decisions on the worst possible basis. I don't like that guy. I don't like that other legislator who's for it. So I'm just saying that outcomes, it's a good lesson in life. Outcomes, you got to be careful about not thinking that you're the lawyer, you're so good, you're going to get what you want, because it really isn't in your hands most of the time. The facts, if you're a litigator, you know, you can develop a lot of facts that maybe nobody else would, but you can run into a wall and you just don't have good facts. So your talent, your ability, and all you guys are going to be great, great lawyers, but it doesn't really, in the end, decide it. And you will suffer the way I've suffered in life if you think, oh, it really should have come out this way. Don't be too invested in that, because you don't control it. You control what you do, what you believe, what exists here. But you don't control powerful decision makers' decisions.
Dennis, you know, I can't thank you enough for doing this marvelous presentation. It's been really, really enjoyable, and I think I did right when you convinced me to come on board 33 years ago.